Hi, I'm Karina Ralston, and I'm a Principal and Director at Coleman Greig Lawyers. I'm an accredited specialist in family law, and I focus particularly on binding financial agreements and complex property structures and high net wealth individuals. Just over 40% of marriages now end in divorce, and that is a higher percentage if the parties are in a de facto relationship or if it's a second marriage. Once there has been a separation, it means that two people are trying to disentangle themselves from each other. That can involve a whole range of situations or circumstances, from one party making a cash payment to the other one, from there being a transfer of property or refinancing a loan, to distributions being made from a trust or a transfer of an asset from a trust or a company to an individual. And there is a whole series of tax concerns and obligations that come as part of that process. There are a number of things that people need to be aware of when they are considering separation and once they're trying to work out what entitlements they have to assets and liabilities. The first is the obligations that they have to provide documents and particulars as to the value and composition of their assets. Those disclosure obligations are really quite significant, and they impact not only the person who is going through the separation, but also to third parties such as parents, business owners, and people that may have an interest in the assets held by that particular party. This can be quite a confronting and frustrating aspect of family law. Not only is the person who is separating required to provide a great amount of material as to their assets and liabilities, but also it encroaches upon the lives of other third parties, and the obligations can, in some instances, be really quite onerous. It's important in these instances to understand what your obligations are and to understand what third parties may be involved and what obligations they have to produce material. Parties need to consider how to prepare their business or prepare their investments for the process that is about to occur. For example, if a cash sum needs to be paid to one person, how does that affect the obligations of the business and their cash flow? What are the goals and strategies of the business for the upcoming year, and how will that be impacted if there is a refinance of a loan or removal of a guarantee or a third party that may otherwise be affected? Are there any anticipated tax liabilities of the business? And is it strategically appropriate to realise those tax liabilities now or to have them roll over to another year? And following on from those anticipated tax liabilities, it's important to think strategically about what assets and liabilities you are retaining and whether there's any tax obligations that arise by virtue of the division of assets and liabilities. For example, there's tax concessions available for the alteration of property interests in the event of a breakdown of a relationship. That can include a capital gains taxation rollover relief, that can include exemptions for paying duties, and it's important to think about how they would fit in to the financial circumstances of a party who is retaining certain assets. Further, if there are taxation liabilities as a consequence of a division of assets, how are they being taken into account? For example, if there is a distribution from a trust to one individual, how will that tax obligation that won't arise in the short term, and likely not until the next financial year, be taken into account now? It's really important that you obtain the right advice and as early as possible as to what the composition and value of the asset pool is. And that way your family lawyer can work strategically with your accountant as to what tax liabilities may emerge, what is the focus of your business or investments, and how to make sure that an individual and the relevant third parties can get through the breakdown of the relationship as easily and as financially appropriate as possible. What I find really interesting in my job is that people feel quite comfortable to talk about asset protection within the scope of the economy or the exchange rate, or if in the event that one of the business partners passes away. But we don't seem to have the same ability to talk about what would happen to a business or investment if one of the interested parties separates from their spouse. And these are the events and circumstances which can disrupt a business far more significantly than other outside factors. And it's really important to think strategically about these aspects now, whilst there's less acrimony, than at a later point in time when things can become more difficult. It is important to speak to a family lawyer when you are looking at succession planning within a business, when you are looking at growing a business, when you are looking at how to weather the storm of a business, to make sure that you are putting the right measures in place to protect this investment for future generations to come.